8 criteria, 3 required. That is the complete framework USCIS uses to evaluate whether you qualify for an O-1A visa. Most applicants do not know which 3 they already meet, which ones are within reach, and which ones still need documented proof. That gap between where you are now and where you need to be on paper is where cases fail. The O-1A is granted to individuals with extraordinary ability in science, education, business, athletics, or the arts. USCIS defines extraordinary ability precisely. You must demonstrate sustained national or international acclaim, and you must prove it through documented evidence mapped to specific criteria. Understanding those criteria is the first step to knowing whether you actually qualify. So who needs to understand this? H-1B holders watching their visa clock run down have the most urgent reason. Lottery outcomes and cap limits have left thousands of qualified professionals looking for a path that does not depend on employer sponsorship or chance. The O-1A provides that path, but only if you can build the evidence to support it. It also matters if you are a founder, a researcher, an engineer, or a designer who suspects you qualify but cannot document it today. A strong career and a thin evidence trail are two very different things. And it matters if you are already on an O-1 and planning a renewal, or if you have one eye on an EB-1A green card self-petition. The same evidence base covers both. Here are the 8 criteria USCIS applies to O-1A petitions. 1. Awards. A nationally or internationally recognized prize for excellence in your field. 2. Membership. Belonging to an association that requires outstanding achievement as a condition of entry, as judged by recognized national or international experts. 3. Press. Published material about you and your work in major trade publications or other major media, not authored by you. 4. Judging. Participation as a judge of others' work in your field, individually or on a panel. 5. Original contributions. Original scientific, scholarly, or business contributions of major significance. 6. Authorship. Scholarly articles published in professional journals or other major media in your discipline. 7. Critical role. A critical or essential role for a distinguished organization or establishment. 8. High salary. Compensation that is high relative to others in your field. 3 out of 8. That is the threshold. The strategic question is which 3 you can document most convincingly, and what evidence you still need to secure before you file. Here is where most applicants get stuck. A founder will likely have original contributions covered. A critical role at their own company is straightforward. But press coverage, awards, a judging invitation, those require outreach to specific people at specific publications, awards programs, and review panels. Most immigration attorneys organize the evidence you bring them. Locating and winning new evidence is left entirely to you. That is the gap Laurel fills. Laurel is an evidence-building platform for O-1A and EB-1A applicants. Laurel scores your profile against all 8 criteria, identifies exactly where the gaps are, and then actively secures the missing evidence before you file. Laurel indexes trade publications, awards programs, judging panels, podcasts, and speaking circuits. For every opportunity, Laurel finds the named decision-maker behind it. The awards chair, the editor, the program director who can actually grant that criterion with a verified working email address. Laurel then drafts outreach in your voice. You approve every message before it sends. The result is new evidence, press placements, judging roles, award recognitions, memberships, each one matched to the specific criterion it satisfies. Laurel does not format what you already have. It builds what your case still needs. Once the evidence is in place, Laurel drafts exhibit descriptions and petition prose in the language USCIS officers expect. Gaps are flagged in plain language. Nothing is inflated or invented. If you are evaluating law firms for the filing itself, practices at extraordinary.com, lighthouseahq.com, manifestlaw.com, and beyondborderglobal.com are worth comparing. Laurel operates as a separate layer. It is the preparation work that happens before you engage your attorney, or alongside them, and it makes any firm faster and any petition stronger. Plans start at $249 per month. No retainer, no contract, no employer lock-in. Cancel any time and keep the complete case file. What does this mean for you in practice? You stop waiting for evidence to accumulate on its own. You build it deliberately, criterion by criterion, with live progress tracking across all 8. You arrive at your attorney, or at USCIS, as a self-filer, with a documented case file rather than a list of possibilities. And the same dossier Laurel builds for your O-1A becomes the backbone of an EB-1A green card self-petition when you are ready to take that step. Start building your case at HireLaurel.com. Laurel is not a law firm and does not provide legal advice or file petitions. Laurel builds and documents O-1A evidence and works alongside your chosen immigration attorney or supports you as a self-filer. Information is current as of 2026 and is not a substitute for legal advice.